Well, good morning, ladies and gentlemen. By my watch, at least, it's about 9 o'clock. My name is, for those of you who don't know me, it's Andrew Grantham, KC. This morning, I shall be addressing the recent decision of the Supreme Court in FCA and Arch Insurance, and then subsequent first instance decisions on the issue of business interruption cover, specifically for the consequences of COVID. Johnny Ward, who has extensive practice in relation to insurance, professional negligence, construction and technology disputes, will then be addressing the professional negligence of insurance brokers in the context of BI cover for COVID. If you'd like to ask any questions, please do use the chat facility and we can address the same at the conclusion of the talk. I very much hope that copies of our slides have been distributed so that you can annotate them during the course of this talk. For those of you who haven't been provided a copy, please do get in touch with our clerks and copies will be provided. Ladies and gentlemen, this is the third time I've spoken on business interruption insurance post-COVID. For reasons that will become apparent, I think, it will not be the last as the law continues to evolve. Business interruption cover is provided upon the occurrence of a specific insured event. The wording of each policy will therefore be critical. Often policies provide an indemnity where financial losses are suffered by a business consequential upon property damage. They won't provide an indemnity where businesses have been affected solely by reason of the COVID pandemic and responses thereto. However, certain policies provide cover independently of any material damage to property, often by way of an extension to damage cover. In FCA and Arch Insurance, UK Limited and others, at the first instance in the Divisional Court and on appeal to the Supreme Court, numerous issues of principle in relation to policy coverage and the various specimen policy wordings underwritten by the defendants were considered in the context of the first lockdown. To some extent, that decision, which is now handed down in January 2021, is somewhat old hat, but it is important to bear in mind the central points decided, at least by the majority, in the Supreme Court, in order to understand the subsequent cases. It's also important to note that not all the issues that were decided at first instance were the subject of the appeal to the Supreme Court. Therefore, it may be necessary to have regard to both the decision in the Supreme Court and the Divisional Court in order to advise your clients. As I say, today I shall address the majority decision in the Supreme Court before addressing some more of the recent cases. So the majority judgment in the Supreme Court addressed the following principal issues: the key events, the categories of business, the insured perils in respect of disease, prevention of access and hybrid policies, causation, and finally trends clauses and pre-trigger losses. Overall, the Supreme Court upheld the appeals of the FCA, albeit in qualified terms, on two issues and dismissed the insurers' appeals. The key facts are set out in this slide, which you can have reference to during the course of the talk, as are the categories of business, which are based upon the categorisation arising out of the health protection, coronavirus restrictions, England regulations 2020, and like regulations for Wales. So dealing first of all with coverage. In addressing issues of coverage, the court identified three groups of policies depending upon the nature of the insuring clause. First of all, disease clause policies, they being non-damage extensions to the standard business interruption cover and require the presence of a defined disease on or in a stated radius of insured premises. Secondly, prevention of access and similar clause policies. That is, those policies where the insuring clause provides cover against the prevention or hindrance of access to or the use of the insured premises as a consequence of government or local authority action or restriction. And finally, hybrid clause policies, that is, those where the insured peril is defined by reference both to restrictions affecting the premises and to the occurrence or manifestation of a notifiable disease. The Supreme Court proceeded to determine the issues of cover by reference to specific policy wording of policies underwritten by various insurers, but used the wording of an RSA policy containing a non-damage BI extension as an exemplar, And you can see, broadly speaking, the cover provided, which was RSA 3, and it provided cover in respect of business interruption or interference during the indemnity period following any occurrence of a notifiable disease at or in a radius of 25 miles of a premises. Notifiable disease was defined so as to include illness sustained by any person resulting from any human infectious or contagious disease, an outbreak of which the competent local authority had stipulated should be notified to them. Indemnity period was defined as the period during which results of the business were affected in consequence of the occurrence, beginning with the date of the occurrence. The Supreme Court first recorded 3 agreed matters. First, by the 6th of March 2020, COVID fell within the description of a notifiable disease. That is a disease notification of which was required by the Health Protection Notification Regulations 2010. Second, for illness resulting from COVID to be sustained by any person, it was sufficient if a person had in fact contracted the disease, irrespective of whether it was symptomatic or diagnosed. Their presence was relevant only to proof. Third, the word following denoted some causal, not merely temporal connection. It then moved on to consider the definition of a peril in the insuring clause. What was meant by the words, any occurrence of a notifiable disease within a radius of 25 miles of a premises? At first instance, the divisional court had held that the peril was the notifiable disease of which the individual outbreaks form indivisible parts. It read the words any occurrence of a notifiable disease within a radius of 25 miles as meaning a notifiable disease of which there is any occurrence within a radius of 25 miles. Alternatively, although the division of the court regarded this analysis as less satisfactory, it held each of the individual occurrences of the disease was a separate but equally effective cause of a business interruption. The majority of the Supreme Court rejected the divisional court's primary interpretation of the insured peril on the basis that it amounted to holding the peril to be the disease itself, that is COVID, whenever and wherever it occurred, provided that there was an occurrence within the relevant radius, with a cover running from the date of that local occurrence. In other words, COVID was indivisible. It was a thing in itself as opposed to the individual occurrences of the disease. Rather, in the Supreme Court, the majority held that there had to be an occurrence of illness resulting from COVID sustained by a particular person within the specified radius in the policy. In insurance law, an occurrence, like its synonym event, has a well-established meaning, namely something which happens at a particular time, at a particular place, in a particular way. And that was reinforced, the court held, by the definition of the indemnity period, which was defined so as to begin on the date of the occurrence. Cover was therefore provided for business interruption caused by any cases of illness resulting from COVID that occurred within a radius of 25 miles of the premises from which the business was carried on. The insured peril was any case of illness resulting from COVID suffered by a person within that radius. The court came to a similar conclusion in respect of similar wording in the Argenta, MSA, and QBE policies. So prevention of access wording next. Prevention of access policies define the insured peril by reference to interference in the use of the insured premises due to public authority action. An example of such a policy was the Arch policy. It provided cover against loss resulting from, first of all, prevention of access to the insured premises, secondly, due to actions or advice of a government or local authority, thirdly, due to an emergency which was likely to endanger life or property. So 3 requirements. Likewise, hybrid policies, they include as one element of the insured peril the requirement for a notifiable disease that in some way was connected with the interference. Example taken was the Hiscox policies, which provided cover against losses resulting solely and directly from an interruption to your activities caused by your inability to use the insured premises due to restrictions imposed by a public authority during a period of insurance following an occurrence of any human infectious or human contagious disease, an outbreak of which must be notified to the local authority. Again, several requirements. So issues arising in relation to prevention of access and hybrid policies. First of all, the disease elements were treated in the same way as disease policies were treated. So specific occurrences had to be identified. In respect of Hiscox 1 to 3, where there was no express geographical restriction, the Supreme Court held that there was no requirement for the occurrence to be at or near the insured premises. Rather, the policy provided cover against the consequences of the occurrence of COVID, irrespective of where they occurred. The second point addressed was force of law. Several policies required the business interruption to be due to restrictions imposed by a public authority or used similar wording. The Divisional Court had held that that requirement entailed a mandatory restriction which had the force of law. The Supreme Court disagreed. It held that word imposed of itself didn't require a valid legal basis for a restriction or the immediate prospect of one. Specifically, an instruction given by a public authority might amount to a restriction imposed if, from the terms and content of the instruction, compliance with it was required, without the need for recourse to legal powers. Such an instruction would need to be mandatory and sufficiently clear to enable the addressee to know with reasonable certainty what compliance required. However, the Supreme Court agreed with the court below that enforced closure of an insured location would not include advice or exhortations or social distancing and stay-at-home restrictions. Nature of the restriction. The court dismissed Hiscox appeal, upholding the Divisional Court's decision that restrictions imposed did not need to be directed to the insured property or its use by the policyholder. Therefore, businesses falling within Categories 3, that is essential shops, and Category 5, businesses not referred to specifically in the regulations, were subject to restrictions imposed, even though they were permitted to remain open. Inability to use. The court agreed with Hiscox that inability to use denotes a complete inability of use. However, that would be satisfied if a policyholder were unable to use the premises for a discrete part of its business activities. For example, a bookstop was only able to use its premises to process telephone orders, or were unable to use a discrete part of its premises for business activities. For example, a department store that was required to close all parts of its store, save for a pharmacy. Thus, the appeal of the FCA and Hiscox and interveners was upheld to the extent that an inability to use might include a policyholder's inability to use either the whole or a discrete part of its premises for either the whole or discrete part of its business activities. That said, it remained doubtful whether businesses falling in Categories 3 or 5 would be able to demonstrate the requisite inability, because inability didn't include hindrance or disruption. And for that reason, Regulation 6 of the regulations, which introduced a prohibition against people leaving the place where they are living without reasonable excuse, would rarely suffice. Prevention of access. The policies underwritten by Arch included in the definition of insured peril prevention of access. The Supreme Court held that access could be prevented to a discrete part of premises or to premises for the purposes of carrying on a discrete part of the business activities undertaken by the policyholder. In each case, access could be completely prevented rather than merely hindered, which would not suffice. For the same reason, businesses falling within Categories 3 and 5 would rarely be able to demonstrate a prevention of access. Interruption. The court dismissed Hiscox's appeal against the Divisional Court's ruling that interruption might extend to interference or disruption, not just complete cessation. Causation. The divisional court's conclusion as to the insured peril in disease cases, that is, that the COVID pandemic itself was the insured peril, meant that issues of causation didn't materially arise. If the insured peril were COVID, all the business interruption losses would be suffered by reason of the outbreak. However, given the meaning the Supreme Court gave to the insured event in disease policies, a significant issue of causation arose. If the peril were each occurrence of disease, but only those occurrences were in the stipulated vicinity were insured, could it be said that the insured perils caused business interruption, when the insured perils were not a but-for cause of the legislative and governmental restrictions? The court concluded that a proper interpretation of the disease policies, in order to show that loss from interruption of the insured business was proximately caused by one or more occurrences of illness resulting from COVID within the stipulated area, it was sufficient to show that the interpretation was caused by government action taken in response to cases of disease, including at least one case within a defined area, for example, a 25-mile radius of the insured property. That was on the basis that each occurrence was a separate and equally effective cause of that action. That was said to be the case irrespective of the precise causal connection stipulated in the policy. Therefore, it applied where the connection required was following, or arising from, or indeed as a result of. In relation to prevention of accidents and hybrid clauses, the Supreme Court applied the same analysis, which contained as one element of the insured peril an occurrence of an infectious disease within a specified distance of the insured premises. In order to obtain cover, it would be sufficient to show that interruption was caused by closure or restrictions placed on the premises in response to cases of COVID, including at least one case within a specified radius. In these policies, establishing the insured peril typically requires proof of a number of elements. Thus, the Hiscox policies required proof of, first of all, occurrence of a notifiable disease, causing, secondly, restrictions imposed by a public authority, causing, thirdly, an inability to use the insured premises, causing, fourthly, an interruption to the policyholder's activities. That was the sole and direct cause of financial loss. In each case, the Supreme Court held the correct counterfactual was not what the financial position of the business would have been, but for the occurrence of the insured peril. That would be to limit the indemnity to loss, the sole proximate cause of which was the insured peril. However, cover was provided against losses proximately caused by an insured peril, along with other perils which were not excluded, and which the parties to insurance would naturally expect to concur concurrently with the insured peril, that is, other consequences of the pandemic. Take an example. Suppose the public authority Therefore, by way of example, the public authority clause in the Hiscox policies indemnify the policyholder against the risk, and only against the risk, of all the elements of the insured peril acting in causal combination to cause business interruption loss. However, it did so regardless of whether the loss was concurrently caused by other uninsured but non-excluded consequences of COVID-19, which was the underlying or originating cause of the insured peril. Take a restaurant forced to close due to COVID within 25 miles of the premises. Its turnover might have been reduced anyway due to other governmental measures following COVID. While those measures were not an insured peril, they were not excluded either. They were thus concurrent cause. Each of those causes was sufficient to cause the loss and arose out of the same underlying or originating cause, so such loss would be covered. Finally, on the arch case, trends clauses and pre-trigger losses. In business interruption policies, the amount of the indemnity is typically quantified by comparing a revenue or profit in the period prior to the occurrence of the insured peril with the equivalent in the indemnity period. However, normally, policies will contain a so-called trends clause, the wording of which will seek to adjust the amount of indemnity to reflect any special circumstance or business trends affecting the business, either before or after the loss, so as to ensure as near as possible that the indemnity reflects the result that would have been achieved if the insured peril hadn't occurred. The Supreme Court held that trends clauses should be construed so that absent clear contrary wording, they arrived at the results that would have been achieved but for the insured peril and circumstances arising out of the same underlying or originating cause. It followed that trends and circumstances that should be eliminated by a trends clause were only those unrelated to the insured peril, so that any causes attributable to COVID were excluded in making the adjustment required by the trends clauses. So moving on to the recent cases, you'll see in this slide the 5 cases that have followed Arch that we need to consider briefly. The first one was Rockcliffe Hall and Travellers Insurance Company Limited. In that case, the policy provided BI cover against infectious disease, which was defined as meaning food or drink poisoning, secondly, cholera, plague, relaxing fever, smallpox, typhus, and then thirdly, 28 listed diseases. The claimant contended that the word plague was sufficiently wide to cover COVID, or alternatively, that the way in which the insured peril was defined was such that any newly discovered infectious peril would suffice. Mrs. Justice Cockrell didn't agree. She held on an application by the defendant to strike out the claim that plague meant a specific disease, bubonic, pneumonic, or septicemic plague, and that the use of the words infectious disease meant that the definition was exhaustive. So the court wasn't prepared to place in it a strained construction to provide cover. In Corbyn and King and AXA Insurance, the claim was made by 11 related claimants, each one of which owned and operated a restaurant or other hospitality venue. They were collectively insured under a combined policy underwritten by AXA, which included a denial of access non-damage clause. The clause provided cover against loss resulting from BI where access to your premises is restricted or hindered arising directly from actions taken by the police or any other statutory body in response to danger or disturbance at your premises or within a 1 mile radius of your premises. And the indemnity was limited to the sum insured or £250,000, whichever was for less. In order to understand the decision, one needs really to refer back briefly to the decision of a divisional court in Arch in relation to similar policies, and in particular MSA 1. It too provided cover in relation to danger within a certain radius, and the divisional court held that meant a localized risk, such as a gas leak or explosion, or bomb scare, not something as wide as the COVID pandemic, and therefore cover would be refused. However, notwithstanding the treatment of such clauses in Arch, this time Mrs. Justice Cockrell favoured the insured. She held she wasn't bound by the decision of the divisional court in Arch because the wording was not identical under the policies, and secondly, the point raised before her was subtly different. She proceeded to construe the clause holding that the word danger was apt to cover disease. She noted that there was no locality limitation other than the radius, i.e. that the danger would be within a 1 mile radius of the premises. The fact that the indemnity period was 12 weeks combined with the fact that cover didn't attach unless the danger persisted for more than 2 hours showed that danger didn't have to be transitory. It followed that insured peril could be one or more instances of COVID within the radius. The next issue was causation, and here the judge followed the Supreme Court. She held that COVID-19 was capable of being a danger within 1 mile of insured radius, which coupled with other uninsured but not excluded dangers, i.e. occurrences of COVID outside the radius, led to the regulations, which caused the closure of business, which in turn caused the BI. She also addressed the limitation of $250,000 and held both as a matter of principle because it was a combined policy and also on a true construction of a policy that the $250,000 limit applied to each of the covered premises. Finally, the 3 most recent cases, I should say before going any further, these 3 cases, Stonegate, Greggs and various eateries, are the subject of an appeal to the Court of Appeal, which is due to be heard on the 27th of November of this year. So it's likely there may be another instalment of these talks next year. But moving on, first of all, Stonegate. In Stonegate, first of all, it's important to note that in none of the cases was factual causation or quantum addressed. Therefore, while the issue of aggregation was considered as a matter of principle, the court didn't determine what losses were to be aggregated with each other. What Stonegate did address were three principal issues. First of all, triggers and aggregation. Secondly, causation in the indemnity period. And thirdly, deductions for furlough payments and rate support grants. The case involved a claim in respect of 760 bars, restaurants and pubs. The policies materially provided for cover till the 30th of April 2020 for BI losses on three bases. First of all, a clause headed notifiable disease and other incidents, which provided cover in respect of, first of all, any notifiable disease, and secondly, BI from enforced closure by executive authority, and the third basis was a prevention of access non-damage clause. For the limits on liability of 2.5 million under the disease cover and 1 million under prevention of access cover, in each case for each single business interruption loss or SBIL. So in terms of the triggers, you'll see from the slide that in relation to disease, the trigger was defined to the occurrence of COVID within the defined vicinity. In relation to enforced closure, the court held that there was an enforced closure whenever premises were subject to closure, and each premises remained closed. The peril continued until the premises either reopened or the trigger changed. In relation to prevention of access, the trigger was each executive action or advice, overall not to be multiplied by reference to the number of premises. You will recall that there were limits of liability expressed by reference to a single business interruption loss, or SBIL, which was defined as all BI losses, etc., arising from or attributable to or in connection with a single occurrence. Two issues therefore arose. First of all, what degree of connection was required between the single occurrence and the losses to be aggregated, and secondly, what events could amount to a single occurrence for these purposes. As to the former, Mr. Justice Butcher held that the definition of a single business interruption loss was such that only a relatively loose causal connection was required between the single occurrence and the losses to be aggregated. However, some causal link was required. In relation to the latter, two single occurrences were identified. First of all, the COBRA meeting on the 16th of March, where people should avoid pubs, restaurants and clubs. Alternatively, held there were three occurrences, one through advice given by the PM for England and Wales, and one given for that for each of the first ministers. The second single occurrence was on the 20th of March, whereby pubs, bars and restaurants were ordered to close, or alternatively again, three separate occurrences, one per jurisdiction. Causation and indemnity period. The second major issue was causation or indemnity period. The claimant contended that its business interruption losses throughout the 36-month indemnity period were caused by covered events that occurred in the period of insurance ending on the 30th of April 2020. The issue arose because of the analysis of the Supreme Court in the Arch case as to insured peril in disease policies and causation therefrom, and indeed the analysis concentrated on Stonegate's disease cover. The issue can be expressed in this way. Because the insured peril was defined to be each occurrence of COVID rather than the pandemic overall, could it be said that insured perils caused BI substantially beyond the end of a policy period, given that the occurrences of COVID after the end of a policy period were not insured perils, but nor were they excluded perils? The claimant's argument was essentially rejected by the judge as a misinterpretation of the Supreme Court decision. The judge held that was because the Supreme Court decision had depended upon a finding of fact that all cases of COVID up to the date of the government measures were equally effective in causing a government response. There was no decision that each case of COVID as a matter of law caused the government response. Therefore, for Stonegate to succeed in its argument, it would be necessary for it to show that all cases of the disease occurring within the period of insurance were equally or approximately equal causes of the various governmental measures adopted at different stages during the indemnity period, and of consumer behaviour at the different times during that period. And that hadn't been established by March. The judge then went on to consider whether or not, as a matter of fact, governmental measures were caused by instances of COVID during the policy period and held that they were not. Governmental support, this is important, and of application generally. Essentially, the judge held that furlough payments were to be deducted from the indemnity because they were generally paid out of turnover. And he held that equally, that insofar as rate support grant was payable out of turnover, they too were fall to be deducted from the amount of the indemnity. Dealing very quickly indeed with Greg's, in essence, in that case, the insurers contended that all business interruption losses arose from or attributable to a single occurrence and to be aggregated as one single business interruption loss. The judge rejected that analysis and essentially held that the same analysis that applied in Stonegate applied. One had to look at the individual, one had to aggregate according to single occurrences, and the judge went on to consider what those single occurrences were. In terms of the indemnity period, there was nothing really to be said in addition to that from the Stonegate case. However, in the various eateries case, two issues as to the indemnity arose. First of all, when did it begin? Did it begin when the insured peril first arose, that is, occurrences of COVID, or only when business interruption commenced? And the judge held that it was the latter, where the indemnity period commenced with the first business interruption caused by an occurrence of COVID. And then in relation to post-policy losses or duration of indemnity, the parties were agreed that this issue turned on whether business interruption losses after the period of insurance were approximately caused by covered events within the period of insurance. The judge addressed this issue separately for each of the covered events. In terms of disease cover, the insurer's primary case was rejected for the reasons addressed in Stonegate, as was the alternative case, which was advanced on the basis that cases in the period of insurance with approximate cause of interruption and interference after the end of that period, at least at the end of lockdown 3. And so that was also rejected. Turning to enforced closure, the judge accepted that it would be a covered event for the duration of any enforced closure, provided that the commencement of the enforced closure was within the period of insurance. The same applied to prevention of access. Provided that the prevention of access commenced during the policy period, the insurer was entitled to cover for the duration of the prevention of access, before and after the end of the policy period. The indemnity would continue until the existing restriction was removed or replaced by a new restriction after the end of the policy period, which was in substance a new prevention or hindrance of access or a new enforced closure. Whether a restriction was the same or new was fact-specific and would turn on the terms and purpose of the original and new restrictions, their legal origins, and whether the reasons underlying each of them were the same or different, together with the identity of the authorities concerned. So, by way of conclusion, there remain cases on business interruption coming through the system. Cases are presently being managed by Mr. Justice Jacob in the Commercial Court, who has taken over Mr. Justice Butcher in that role. The Stonegate cases are due to be heard later this year, and I shall look forward to the next instalment in the coming year of this continuing developing area of law. Thank you all very much.
As we've heard from Andrew, the decisions in Arch have provided helpful guidance as to the legal interpretation of particular types of clause in business interruption policies. But as we've also seen from the subsequent decisions, there are still plenty of bases on which cover may be declined in any particular case. And often the first port of call when an indemnity is declined, rightly or wrongly, is the broker. So this talk is going to look at potential broker liability by reference to long-standing principles, and also to consider how these might be applied in the context of claims arising out of COVID-19 and the restrictions. So I'm going to aim to cover the following principal matters, which are set out on the slide. Firstly, where the duties arise, what those duties are, the standard of care that is expected of an insurance broker, causation, so has the breach, if there is a breach, has it caused any recoverable loss? And then I'll look at how some of these issues might play out in the context of BI cover caused, or BI losses caused by COVID-19 and any pandemic restrictions. So let's begin by looking at the sources of duties on brokers. These might arise in contracts, they might arise independently in tort, or they might arise in both. And note that the typical activities of brokers are a regulated activity under the Financial Services and Markets Act 2000. There are specific duties indeed set out in ICOBs, and some of those are directly actionable. And note also that the Insurance Act 2015 is still fairly recent, and many of the cases we come across predate the Act. And the 2015 Act is relevant to broker claims because, firstly, of the repeal of previous statutory obligations on brokers vis-a-vis insurers and disclosure, and because of the duty or the new duty of fair presentation under the Act, which will to some extent inform the scope of duties that the broker owes to the client. So the standard of care, as with professional liability generally, the overarching duty is to exercise reasonable care and skill in all of the circumstances. And the relevant provisions of ICOBs will be relevant to the standard of care even when an action is not brought for breach of statutory duty, because a reasonably competent broker would be expected to comply with those provisions. And there is some dicta in the authorities that suggests generally the bar is set quite high for brokers and the duties tend to be quite onerous. An example of that we'll see in the EnvironCom decision a little later. And to some extent, the onerous nature of the duty flows from the often confusing nature of insurance arrangements and the many traps for the unwary. So now let's look at some of the duties in a bit more detail. A good starting point is a fairly recent, albeit pre-COVID case called Dalland and Butterworth Spengler commercial. And this was a decision of Mr. Justice Butcher. And he quoted from Jackson and Powell. And the duties there are set out on the slide. 1, the broker should identify the type and scope of cover which the client needs and advise the client accordingly. 2, take reasonable steps to arrange the insurance cover which the client has instructed him to obtain and which is suitable for and clearly meets the client's requirements. 3, in placing the insurance, the broker must have regard to the obligations of disclosure owed to the insurer. Once the cover has been placed, the broker should consider and explain to the client what cover has been arranged. And at renewal of an existing policy, the broker should go through the same exercise that was carried out at the inception of the policy. So he took those directly from the pages of Jackson and Powell, and he made it clear that he regarded those as correctly stating the law. And it's worth noting that in that section of Jackson and Powell, the editors say the following: most of the cases in which a broker has been found liable for breach of duty are ones where the broker has failed to act with due skill and care in the performance of one of those steps. And note that the first item there is effectively equivalent to 5.2.2 of ICOBs, which is the preparation of a statement of demands and needs. Now, very often, and for obvious reasons, claims against brokers will arise where a client insured has been unable to make a successful claim on a policy, whether that's because there simply isn't a policy that responds, or because of a breach of provision or non-disclosure or whatever else. So I'm now going to consider where the broker stands in such a scenario. And in particular, does it follow from an inability to make a successful claim on a policy that the broker must be in breach of duty? So there's a provision, there's another passage from Jackson and Powell quoted on the slide. If the insurance obtained by the broker is such that his client becomes involved in a legal dispute with the insurer, then, unless the position taken by the insurer is absurd, the broker will be found to be in breach of duty. Similar point was made in the ABN AMRO decision, which is mentioned on the slide, where the judge said it was common ground on the pleadings that the broker owed duties of reasonable skill and care to the bank to procure the insurance cover required by the bank and to procure cover that clearly and indisputably met the bank's requirements, so it did not expose it to an unnecessary risk of litigation. See also Mr. Joseph Tomlinson in Standard Life and Oak Dedicated. Similar point was made there. However, some qualification of the extent of this principle was expressed in the Dalland case, which we'll come back to in the context of causation. In the Environcom decision, citation is on the slide, one particular facet of the duty to procure suitable cover is ensuring that the client understands what must be disclosed as part of the procurement of the policy if the policy is to be effective, and to explain its effect. It is further illustrated by Environcom. There's a quote there which, again, it relates to the often harsh effects of the law of insurance. It's really talking there about disclosure, but I think it's also apt to describe the effect of some of the provisions and the way that words are used in these policies, which often have a slightly different meaning to general business or accounting parlance. The need to explain the terms of policies is perhaps particularly relevant in the business interruption context, because almost by definition, these are more complex than typical property damage or even liability policies, because often in business interruption policies, we see terms that are used in a different way from their most obvious meaning. For example, definition of insurable gross profit. This is typically used in policies in a different way to how it would be used in accounting parlance, for example. And similarly, policies are likely to have what's called an average clause. Now, the effects of different categories of average clause is a topic that really needs its own seminar. But for present purposes, I'll simply note that it's relevant where a client is underinsured, because it effectively reduces the value of a claim in proportion to the extent of any underinsurance. And it may mean that a client will recover significantly less than the nominal limit of the indemnity, and they may be taken to effectively be a co-insurer for the loss that has been suffered. Or to put it another way, the policy will not pay out the headline amount of cover where that amount is met or exceeded if there is underinsurance. And as we'll see in the Eurokey decision, significant underinsurance may lead to the insurer seeking to avoid the policy. So that's why it's incumbent upon the broker to assist the client in properly calculating the gross profit for the purpose of fixing an appropriate level of cover. Similarly, aggregate provisions, and to check that the policy is suitable for the client's needs, having regard to such standard form provisions. So let's look at the Eurokey decision. This was a policy, or this was a case which involved a policy which covered business interruption. As it turned out, the client was significantly underinsured. There was a fire, substantial disruption, and an insurance claim was made. The insurer threatened to avoid the policy. The client then settled with the insurer for substantially less than its loss and claimed the difference from the broker. And the question arose, who was responsible for the underinsurance? Ultimately, the case turned on its facts because it was found that the broker had acted appropriately, and responsibility for misstating the relevant gross profit figure lay with the insured client. There's some interesting discussion, nevertheless, about how far a broker needs to go to ensure that the profit calculations are correct and the level of advice that needs to be given. Also, some useful discussion of the relevant principles of BI insurance. But as we've seen, the gross profit is a crucial concept, and different contractual definitions are used in different policies. Note the quotation about the expert's approach to calculating this, which it will obviously depend on the precise contractual terms, but this may be at least a good sense check. So the experts there said that a simple and safe approach was simply to take turnover less purchases. Anyway, in this case, the judge found that the broker had given an adequate explanation, and there were also comments about what would have been decided as to contributory negligence had the claim been made out. Now, causation, as with most areas of professional negligence, interesting questions of causation tend to arise. And as already noted, a claim against a broker will often arise where the insured is unable to get a full or any indemnity from the insurer. Often a combined action will be brought against the insurer and the broker, but sometimes an action against a broker will follow a claim or settlement against the insurer, as was the case in Eurokey. But what if the client doesn't proceed against or settle with the insurer because the client believes the insurer would have a good defense. There'll be some obvious examples where no policy was actually procured. But what about if there was a policy, but the insurer has raised an argument and the client simply proceeds directly against the broker? Now, this is what happened in the Dalland case. And there were two main issues on causation. Number one, what must or who must prove what would have happened if the insurer had been sued? And secondly, what if the broker says that the insurer would have successfully defended an action on some other basis, having nothing to do with the alleged broker's negligence, for example, breach of a condition precedent during the term of the policy? So what Dalland, the claimant, said, it relied on some of the points we looked at earlier in relation to duty, namely that a broker owes a duty to procure a suitable policy and protect the client from the risk of litigation. So the argument went, if the insurer has raised an arguable defence, the broker must be in breach of duty and therefore be liable to the client. And the client is then entitled to damages from the broker without proving that an action against the insurer would have been unsuccessful. And on the second issue, in relation to other bases of defence, these were to be considered only on a loss of a chance basis. Well, the judge thought Dalland was taking this line of argument a little too far. And why, he asked, would a client ever bother suing an insurer if the insurer had raised a defence in correspondence when it could go directly to the broker for a full indemnity without the defence actually ever being adjudicated upon? And you can see the quote from that case on the slide. So Dalland didn't succeed on that issue. They would need to show that a claim against the insurer would not have succeeded, and that was to be established either as a matter of law or on the balance of probabilities if it was a factual matter, and not simply on a loss of a chance basis. A further quotation on the slide there in relation to that point on causation. As to the second issue, which was independent defences that the insurer could have raised, well, Dalland was also unsuccessful on that point. Such defences also had to be considered and decided by the court hearing the claim against the broker. And they actually had to be decided not merely on a loss of a chance basis. So the upshot of this decision seems to be that although, as a matter of duty, a broker should exercise reasonable care to avoid exposing the client to a risk of litigation on arguably unsuitable policies, as a matter of causation, it won't be enough to show that the insurer has raised an arguable defence. The client needs to go further than that and needs to be prepared to prove that such a defence would have been a good one, or to proceed against or settle with the insurer before involving the broker. Where does this leave parties who have been underinsured or not properly insured in respect of business interruption arising out of the pandemic? Well, I expect that some familiar issues will arise. For example, did the broker properly advise as to the suitability of cover under its statutory, contractual, or common law duties? Was proper advice given in relation to the insurable gross profit? Was the basis of calculation explained and the proper information elicited? And were any average clauses and underinsurance possibilities explained and taken into account? Was the maximum indemnity period properly set, and was proper advice given about making proper disclosure to insurers in the usual way? And these issues are likely to be resolved on the same basis as discussed in Dalland and the other cases we've just seen. But we're also likely to see some new issues arising, or at least a different focus perhaps in some of the litigation of this type. I think there can be a natural inclination to identify risks by reference to experience. And the fact is, the pandemic was very different to the business interruption scenarios that we've seen in living memory. And it may be that the case that brokers understandably focused in their advice and discussions with clients on considerations that might arise in cases of fire or flood or other instances of physical damage that everyone was more accustomed to dealing with. And it might also be the case that clients were less interested in insuring against a pandemic. Perhaps it always seemed more of a theoretical possibility, or the effects were harder to imagine than those of a flood or a fire. Or at the least, there may be disputes between brokers and clients as to the client's willingness to leave certain categories of risk uninsured because they regarded them as being particularly remote. Obviously, that doesn't mean that brokers haven't always been under a duty to advise as to adequate coverage against the effects of disease and pandemic and restrictions. And as we've seen, the policies were available in one form or another, and proper advice ought to have been given. And I wanted to say something about expert evidence in this context, because it will often be the case that a court will hear expert evidence as to the appropriate practice of brokers in various scenarios. And we saw an example of that in Eurokey as to the proper way of calculating insurable gross profit. And I think that it will be interesting to see whether experts will have very different views as to the appropriate way of explaining aggregate clauses, for example, in the context of pandemic business interruption or maximum indemnity periods and the like. We've seen some good examples from Andrew as to how these provisions might not work as they would have been expected to work in a pandemic scenario. Because, for example, a client might have negotiated a lengthy indemnity period extending well beyond the duration of the policy, only to find that that won't necessarily help if the ongoing disruption is attributable to what are defined as later occurrences. So I think some of these interesting questions will arise, and we'll certainly look out for those as they filter through the system. And so in conclusion, we're expecting to see a variety of disputes between brokers and clients arising out of the pandemic. The FCA test case considered some specimen wording, and we've got some clarity now as to the legal meaning of some of these clauses. But the reality is that a lot of disputes between insurers and clients and brokers will turn on more mundane factual considerations. In many cases, it will be clear that the client didn't have effective cover against the effects of the pandemic. At least some of those disputes are likely to end up involving the broker. So I've tried to identify some of the considerations that are likely to arise in such claims. So thank you for that. I think we might have 5 minutes for any questions.
Thank you very much indeed, John. I've got one question I can see immediately from Mara Gosling, who asks, do you think that directors may potentially be criticised for not having BI cover in place, for example, by way of breach of director's duty? Well, the first point to note is that most BI policies wouldn't provide cover for the consequence of COVID because they generally speaking, the BI cover is parasitic upon the proof of damage. In those circumstances, can a director be criticised for having or failing to arrange for non-damage related BI cover? I think it would be harsh to do so. As I say, these are relatively unusual policies to have. And whilst it's not beyond the realms of possibility that a director might be held to have acted without a requisite degree of care under Section 174 of the Companies Act, I think it would be harsh. I have a question which was asked actually before the talk even began. Have clients had issues with sequencing of events? For example, a decision to cease operations on public or patient health grounds in accordance with existing health regulations, potentially prior to more formal public authority restrictions specific to the pandemic, ultimately with materially the same effect. I think this is answered by my analysis of pre-policy losses and trends clauses. If the restrictions that predated the policy claim period were due to the same originating cause, i.e. the COVID pandemic, they would be stripped out when considering the standard turnover. So you wouldn't reduce standard turnover by reference to the diminished or diminution in turnover by reason of restrictions imposed due to COVID, even though the legislation wasn't specifically COVID-based. I have a question. What is the current position with at the premises cases? Could that attendee please clarify precisely what the question is? I'm not entirely sure what further assistance you require on that one. Another question I have on the chat is, have clients had issues in the claims relating to evidencing public authority restrictions impacting supply chains in other countries? I don't believe this issue has been directly addressed since the Supreme Court decision Arch, which itself doesn't address the issue. I am, however, aware that in Ireland, in the continuing hypertrust and FBD insurance litigation, there is a decision on this, which you can obtain very easily by going on the internet. The reference to those who wanted is 2021 IEHC 279. And the short answer is, if you look at the Supreme Court decision, if the restrictions imposed overseas are attributable to the same originating cause, then they are concurrent, non-excluded causes, so that you still can obtain cover, provided that you can identify an insured peril. So let's take a situation in which a business has a disease policy. There are cases of occurrences of COVID within 25 miles. But in addition to the effects of that occurrence, or those occurrences of COVID, the business is also affected by international restrictions. I think there is a fair prospect, in the light of the Supreme Court's decision, that cover would still be available on the basis that both the international restrictions and the domestic restrictions were concurrent causes of the loss. However, if all of the losses were solely caused by the international restrictions, I think the argument would be harder to maintain. With another Q&A question, if a client goes into administration as a BI and then seeks to make a claim against their broker for non-indemnity of a BII policy, what would courts consider to be applicable indemnity period? Would it go beyond the point of entering into administration? Johnny, do you want to look at this one, and then I'll come back if there's anything else to add?
Yeah, I mean, obviously, the starting point with all of these is the terms of the policy. So usually in a policy which covers business interruption, there will be a maximum indemnity period, which will overlap to some extent with the policy period and may extend beyond it. If the losses are attributable to the insured peril, then depending on the provisions of the policy, I would have thought the starting point would be, well, what is the maximum indemnity period? So I think that would be my starting point with that. I don't know, Andrew, if you have anything to add.
All I would say is, in the light of the Stonegate cases and the other recent cases, you need to assess whether or not post-policy the losses are attributable, approximately caused by occurrences during the policy period. And that's a fundamental point. You'll recall in Stonegate, there was an argument by reference to analogy of the Supreme Court decision that because each individual occurrence of COVID was a concurrent cause, that cover was available, notwithstanding the fact that the insured couldn't claim an insured peril was a but-for cause. So the argument made in Stonegate was that all subsequent measures were caused inter alia by during the policy causes, but that argument was rejected. So one always needs to ask the question whether or not the post-policy period occurrences were the sole cause of the losses suffered. If they were, then there's no indemnity, even though the maximum indemnity period hasn't expired. Well, thank you all very much indeed for attending this morning. I hope you have a good day.